Hello everyone, I'm Professor Agне Twaronavичiene from Mikolas Ромерис University, Lithuania, our university located in Vilnius, so greetings from my nice city. I'm really happy to be here and I'm happy to present you Lithuanian experience in regard of application of mandatory mediation. So I will share my slides. So my topic is mandatory mediation, Lithuanian model and experience. So it should be mentioned that I structured my presentation into 4 parts. First of all, I will shortly introduce you about the main presumptions, how mediation came to our legal system. After it, I will describe you briefly the family mediation model, which currently is applied in Lithuania. As well, I will talk about impact that model already did and some challenges, of course, some challenges which are already noted. So talking about of development of mediation in Lithuania, it should be mentioned that firstly, mediation was introduced to Lithuanian legal system in the form of judicial, or in other words, court-connected mediation. It was pilot project which started from 2005, and in several years the results of this pilot project showed a great potential for mediation being applied in civil dispute, and year by year it became just a simple part of civil procedure, and nowadays in all civil cases judges during their preparatory hearing normally encourages parties to participate in mediation in civil dispute. As well, we have mediation in administrative disputes as well. Next step in development of mediation in Lithuania, of course, was implementation of mediation directive in 2008. We had a big hopes that now when we got a new law on mediation, it would be easier to practice, it would be easier to form the profession of mediation, community of mediators. But reality showed that simply by implementing directive, no miracle happens. And in case of Lithuania, we had to reform all mediation system in order to gain real, special important results of application of mediation. So it was done in 2017 when our law on mediation was changed substantially, and we institutionalized the Institute of Mediation. And from 2020, from the very beginning of 2020, mandatory mediation in family dispute was started to apply. So nowadays in family dispute we do have mandatory mediation. What kind of dispute? Actually, it's all family dispute, which according to the law on civil procedure may be solved by the settlement agreement. Of course, there is certain categories of disputes which are not allowed to settle, so of course it was left purely on discretion of the court to decide upon. What is mandatory? Mandatory is to initiate mediation before filling up the claim to the court. Is some kind of precondition of coming to the court to start mediation process. Actually, it's not mandatory to mediate, it's mandatory to initiate that mediation process. Any exceptions? Mediation is not mandatory if there was a domestic violence record. In this case, victim has a right, but not an obligation to initiate mediation. So at first, we did not have any exceptions of that mandatory family mediation rules, but step by step it came from the certain group of our parliament members who were worried about mandatoriness of mediation in domestic violence cases. But still, the practice showed that these exceptions are not very popular, and people rarely use that possibility to escape mandatory mediation on the ground of domestic violence. Funding. Of course, money always matters, so mandatory mediation in Lithuania is funded by state actually, and it is very interesting that our state decided to fund mediation services for all disputants who are residents of Lithuania. So it's not depending on income of the people or some special status, just for all residents. Time restrictions are applied because it's impossible to fund everything. So 1 hour is financed for the preparation to the process, 4 hours for mediation process itself, and 1 hour for formalization of mediation results. So in general, we are having, like as a mediators, 6 hours of the process. And of course, parties and mediator are encouraged to enter into agreement if 6 hours are not enough for the proper mediation process and finding a settlement. Implementation of mandatory mediation in Lithuania is also quite original and interesting because it was provided a new function for state-guaranteed legal aid service, and that institution is responsible for the implementation of the mandatory mediation in Lithuania. And private mediators are providing state-funded mediation services under the contracts with state-guaranteed legal aid service. And this institution is responsible for initial stage of mandatory mediation and appointment of the mediator. After that, mediators are providing their services as usual, and only at the end of the process they are submitting documents for the payment for state-guaranteed legal aid service. And we have some nice electronic system which operates well and helps to save a lot of time in doing all these submissions of the documents. A scheme of mandatory mediation in Lithuania, please have a look. So disputants may apply for the mediation services to selected mediator or state-guaranteed legal aid services. They can do it together, but mostly, to be honest, mostly one of the parties to a dispute apply for the mediation to the selected mediator or state-guaranteed legal aid services. So just if we take into account these 10% approximately disputants who apply together, like both parties to a dispute are writing one request for the mediation services, mediator starts the mediation process or state-guaranteed legal aid service appoints a mediator for state-funded mediation services, and that mediator enters into the contract with parties, or parties are informed about the appointment of state-funded mediator, and all the process takes part. In case of the settlement, parties are assisted in preparation of settlement agreement. In case of unsuccessful mediation, parties are provided with a document confirming fulfillment of their duties to mediate before the court. Situation is different if one of the parties is initiating mandatory mediation. So normally as well, he or she applies for the selected private mediator or state-guaranteed legal aid services, and either mediator or state-guaranteed legal aid services sends letter for the other party to dispute for his or her consent to participate in mandatory mediation, and it is provided with a 14 days time limit to reply. And in case of positive answer, mediator enters into contract with parties, or if it is state-guaranteed mandatory mediation, state-guaranteed legal aid service appoints mediator, and the process takes its way. In case of silence or negative answer, mediator or state-guaranteed legal aid services informs the initiating party and provides a document providing that he or she fulfilled the duty to apply for mandatory mediation, and it simply opens gates for the court proceedings. Statistics, so you can see numbers in Lithuania. So the number of applications submitted to state-guaranteed legal aid services by both parties is very low. I already mentioned that it is less than 10%. In about 60% of cases, last year we saw 57% of cases, the second parties did not agree to mediate, and the process ends in the initial state. So that's one of the biggest challenges in Lithuania, how to encourage more people, more future respondents to be involved in the mediation process. And the success rate of mandatory mediation at first was 38%, and now in 2021 it was 56%, and in 2022 54%. So we see that from the first year of application, the qualification of our mediators is getting higher and the success rate is increasing. So you can see here numbers of application every year, number of mediators appointment, and number of settlements agreement. So these numbers might not look very impressive because they are like quite low, like 7,000, 3,000 appointments, more than 1,500 of settlement agreements. But we should remember that before that, mediation in family dispute in Lithuania was not popular, and it was like maybe only some private initiatives and maybe like 100 cases per year. So of course for us these numbers are a miracle, and we strongly believe in power of mandatory mediation. About the impact, so if we take a parties to a dispute perspective, general evaluation of mandatory mediation process is 7,4 if we measure it in 10-grade scale. So it's quite positive, I would like to say. And positive aspect mentioned by the parties to a dispute, that mediation is informal communication opportunity. They feel that it is necessary in disputes. Assistance of the professional mediator makes big difference, and possibility to save money and time is very important for the parties. There were also some negative aspects. Relatively low competence of the mediators was noticed, so it's the sign to work more in that field, and additional formality and obstacle seeking for the court proceedings. Some of the respondents of the survey saw that it might be like some kind of obstacle seeking for the court proceeding. And all this data is from the ex post evaluation, which we already had, and evaluated the impact of mandatory mediation towards the civil family dispute resolution system. And if we talk about attorneys at law perspective, there is positive aspects, that more time for the preparation for the court proceedings, additional opportunity to settle, wider spread of information in regard of benefits of settlement, and some negative aspects, relatively low competence of the mediators, additional formality, lack of clarity in the attorney's role in the mediation process. So we can see that still that role is not clear, and year by year attorneys and mediators are seeking for the best partnership scheme in mediation. And if we take judges' perspective, for positive aspects, that more settlement, so it means lower workload for the justices. After the successful mediation, parties to a dispute are more ready for the court proceedings, and judges also noticed a wider spread of information in regard of the benefits of mediation and settlement. Some negative aspects, that certain number of cases when mandatory mediation was started only formally appeared, and that formality worries our judges, and also less attempts from the side of judges to conciliate the parties during the court proceedings, and less court-connected mediation processes in family dispute. Talking about challenges, so the liberal model of mandatory mediation, which was implemented in Lithuania, faces difficulties to involve second party, as you saw from numbers, to a dispute into the process. Initiating parties do not have other options, but second parties can choose whether to participate or not. They are not facing any real negative consequences in case of their refusal to mediate, and for the more effective implementation of the process, we should and we are searching for some kind of improvements of existing mode. And there are no specific qualification requirements for the mediators who are willing to practice in family dispute. The need for the development of the competences of the mediators in this field is obvious. General requirements, which consist in Lithuania 40 hours basic mediation training, university degree in whatever you like, area, passing mediator's qualification exam and impeachable reputation. These requirements are not sufficient, dealing with highly emotional and complicated issues. More than 45% of mediators in Lithuania start practicing only after basic training, as some exceptions for general rules are applied for judges, attorneys at law, notaries, and bailiffs. And also for the future development of the mediator's profession in Lithuania, it is crucial to set up standards of their behavior. So currently in Lithuania, we are having that European Code of Mediators Conduct. It's applied as imperative even, but this document does not cover ethical issues related to newly emergent issues as distance mediating, mandatory mediation, and etc. And for finishing, I also would like to name the challenges of lack of monitoring of the mandatory mediation. There is no data concerning private mediation processes. In order to see the full picture of the implementation of mandatory mediation, the necessity to register all the processes is emerging. In addition, researchers are facing difficulties in counting the impact of numbers as well. For example, it is really difficult to count how much money do we save if we do not know how exact number of mandatory mediation processes. Also, the length of those processes changes in the court workloads, and etc. So thank you for listening. Thank you for your attention. It's a pity that I'm not here in Bulgaria, not able to answer your questions right now, but I would be happy to answer your questions by email. So please just take your opportunity, and in case you have some requests about the Lithuanian mediation model, do not hesitate to ask. Thank you and bye.